Hi and welcome. Would you please state your name and profession?
Yep, it's Tim Cowen and I'm a barrister.
Excellent. And why did you specialize in competition law?
Well, the short answer is because I wanted to understand how things work. I was terrible at school for taking things apart and to understand how they work. So I once took a lawnmower apart to see how it worked. I did put it all back together again, but there were some bits left over. I haven't really changed.
So now you're doing the same with markets.
Yeah, well, you kind of want to understand how markets and systems function. And so, I mean, where competition law is actually important is that it's one of those things that underpins all markets, all regulation, and the basic principles and theories apply pretty much to all things. I mean, you know, we can have a broader discussion about that, but without it, you wouldn't have plurality of the media and democracy, as well as you know, the more basic and obvious things like differentiation of products.
So that actually takes us to today's topic, because we're here to talk about cloud computing. And in your experience as an antitrust lawyer, what are the competition issues that cloud computing has posed in the past, but also could potentially pose in the future?
Well, we've had we've had a few different issues come up. There's been concerns really from the beginning that people were going to create cloud platforms or data centers that are used on a decentralized basis and lock applications in or lock services in or functionality that then limits the availability of that functionality to others. Whether it is or isn't a competition issue really depends on how many platforms and what the alternatives are and whether the economics can be replicated. I mean, if you look at the systems that are in place, you know, with the big players like, you know, Amazon Web Services or Microsoft Azure, they've got such huge capability. They've got such low costs and economies of scale and scope that the problem really is for smaller players. Whether that's a competition issue depends on whether you're looking at competition between platforms or competition between apps. And we've had that problem recently with you know, smaller third parties saying that it's competition between apps that really matters, and therefore they need to be able to get access on non-discriminatory terms to Microsoft's platform. Microsoft, I think, has very ably and very cleverly simply said, yes, of course we're going to provide access to the platform, which I think it makes sense against a number of different parameters. You know, it makes good business sense. It makes good sense from the fact that you're keeping the regulator off your back or the authority off your back. But whether you have a defense is a different matter. I mean, it's quite likely that it would be open to a player like Microsoft to say, well, no, I don't need to do this as a matter of the strict interpretation of the law. But they've decided to accommodate the interests of the smaller apps players instead.
So speaking of the big players, please answer with a yes or a no. Is the Digital Markets Act a sufficient tool to counter antitrust issues in cloud computing?
I think the DMA suffers from a criticism that I've made before, which is it's a list of things that have happened in the past. And as a result of that, it suffers from the problem of fighting last year's battles or the last decade's battles. So whether it's cloud computing, and we talk about it now as cloud computing, we used to call these things data centers or centralized computing. You know, there's always a shift between the center and the edge of networks. And fundamentally, with an improvement in interoperability, interop standards, access, perhaps some antitrust intervention that we're seeing outside of the Digital Markets Act, what you're likely to see is an improvement in the opportunity for apps providers to provide their services anytime, any place, anywhere. So they effectively can operate on a decentralized basis, which is always the promise of the web. Those that try and centralize and control and create walled gardens are always going to be subject to attack as a result. I'm a bit skeptical about the DMA, I'm afraid. I mean, I know people have put a lot of time and effort into creating it. If it's useful, it'll get used. If it's not, we're going to use the other laws. And you know, whether that's antitrust law is a deep question. Most people, when they're facing somebody who fails to supply you, simply goes and get an injunction for enforcing the contract that you're under to continue to maintain supply, rather than bother with antitrust. But antitrust provides that safety net if the contract doesn't work, or if there isn't another, if there isn't another law that you can reach for.
So I would interpret that as a no.
Maybe. It's a maybe rather than an absolute.
Okay, good. Well, that was one of my
no.
options, so you're right.
Yeah.
Finally, what is the one thing that every competition lawyer should know about competition law post-Brexit?
One thing that every competition lawyer should know about competition law post-Brexit. I think that my basic point is nothing much really has changed, but what you're getting at is, well, what has changed? I think that the one thing that has changed is that the CMA in the UK is now a lot more active. So it's a third country by comparison with the EU. And also the courts in the UK are very open, and they're very open to breaches of other laws. We've always, nothing to do with competition law, we've always been a venue where there's a huge number of fights between different Russian oligarchs have taken place through the UK courts. So if there's a dispute, commercial dispute, it's a very convenient place to litigate, and the jurisdiction of the courts is quite extensive. It varies by different law, but at the same time, it's a place that can litigate and will continue to be a very convenient forum for litigation. The obvious point is that you've got access to a very established practice on things like disclosure, production of documents, but also there's a very active funding market. So you can get access to money to support damages claims and things of that type.
So there's more to come.
Well, yeah, but I don't think much. I think from that point of view, if you had a breach of competition law that affects the whole of the EU, it's likely to affect the UK. Where would you sue? You're probably going to end up with the UK.
Okay, so that the test of time will tell. For now, we're looking forward to talking to you in competition law and conversation in a minute.
Okay.
Thank you so
Thanks
much.
very much. Cheers. Thanks very much.